Good afternoon, everybody, and welcome to the webinar. My name is Bradley Bailyn. I'm a small business litigator, and today we're going to be talking about the wonderful days when people threaten to sue you or when someone actually does go ahead and sue you. What is it that you are going to do to keep your sanity and keep your business and keep your personal assets and help make sure that you're as safe as you can possibly be and the lawsuit is brought to the least costly and quickest resolution. I'm going to go into full screen mode here so you can see my presentation. Okay. All right. What to do when you get sued and what not to do. And if you have questions, please feel free to stop me at any point along the way or type your questions in, and I will be happy to answer them. Okay, so again, this is a picture of me. Some of the cases that I have litigated recently will be used as examples here. I'm a small business litigator. I deal with the kinds of cases that the people in this audience are likely to have on a regular basis and hopefully can share some valuable insights with you. Please feel free to connect with me on LinkedIn. I post on LinkedIn almost every day, as well as to email me and get on my monthly, I don't want to call it a newsletter, but update where I send you information about the law and about other interesting stories and examples and tips that may be relevant to you. Also, for the people who watch this, you're welcome to call me for a free 15-minute consultation. Normally, if you're not one of the people who attends my live webinars, this will not be possible. If you call the normal phone number, there is a fee for speaking with me, but if you are here today, you get to bypass that and get a free 15-minute consultation. At any rate, what have we got here? This is what our agenda is going to look like. Finding out you've been sued, what to do after you've been sued, and you have a lawyer, now what? Remember, this presentation is for informational purposes only. It does not create an attorney-client relationship. It does not constitute legal advice, and there are many other facts which could affect the outcome of the hypothetical scenarios presented. In plain English, don't rely on anything that I say. Ask the law in your particular situation, because the law has many pages to it and books of the law. And then there are exceptions and exceptions and exceptions to the exceptions and cases that interpret the exceptions to the exceptions, and just basic common sense and experience relating to the way certain judges in certain counties are likely to interpret certain facts in light of all of the stuff we said. So there's a service that lawyers provide that Google does not provide, which is having some kind of context and understanding of where your particular issues fit in with the overarching scenario. All right. So bottom line of it is, this is just to make you more educated. It's not to replace me or other people who do what I do. All right. Part one, finding out that you've been sued. You will be served with lawsuit documents. What does served mean? The most common way that you get served is somebody knocks on your door, you open the door, and they hand you an envelope and they say, "These are legal papers," or something to that effect. Sometimes they try to snap a picture of you as well. And so that's known as personal service. The purpose of service of the papers is to legally make sure that you've been notified of the case which has been brought against you, because it would be unconstitutional for there to be a judgment against you and for them to just go and hypothetically empty your bank account if you never even got your day in court, if you never even knew you had a chance, that you were being sued and could defend yourself. So the notice requirement of a lawsuit is very important, and service fulfills the notice requirement. Also, if you hide every time that they try to serve the papers, the next thing they're going to be allowed to do is what they call nail and mail, which means they just put a copy of the papers on your door, and they also mail you a copy of the papers, and they figure you can pick up the mail and read them at your own leisure. That's also considered valid notice for you. Other things that can happen is there's an authorization for them to publish it in the newspaper. It really happens almost never, but there are cases when notice is considered acceptable by publishing it in the newspaper because they just can't find you anywhere. And then also a lot of times someone calls you up and they're like, I sued you, I sued you. Or like their friend calls them and say, hey, I just saw that there was a lawsuit filed against you, or some lawyer sends you a letter to ask if you need, or an email to ask if you're going to need counsel, if you're going to need a lawyer because they see that you've been sued, or maybe they'll email it to you. So, someone will find a way. Your day will get ruined one way or another. They'll figure it out. And these are basically the ways that it happens. So, okay, Christina, yeah, that's a good question. Christina is just asking what happens if they never actually give you notice and they sue you anyway, and they just say that they gave you notice. That's called sewer service, and it happens on a quite a regular basis. Whenever it is that you do find out about it, at that point, we file paperwork with the court swearing that you never received the proper notice. And most of the time, the court will just allow you to defend yourself. Excuse me. The court will allow you to defend yourself at that time. If there's really honestly a question about it, they can have a hearing and they can question whoever it is that served process, that claims they served the notice on you, and determine whether in fact they did it or not. But typically the court doesn't even want to waste their time with that. If you honestly had no idea about the lawsuit, then usually the court will cancel out whatever paperwork they filed and allow you to begin the process again in earnest. Okay, right. Okay, and Jared, that's also a good question. What happens if someone sues you in another state and it's not reasonable or possible for you to defend yourself in that state? Are you obligated to go and defend yourself in California? Well, you have two options there. One option is to hire a lawyer in that other state to try and fight their ability to sue you in that state and hopefully have it dismissed and make them sue you in the correct state. The other thing that you can do, and we're going to talk about this a little bit more, is known as defaulting, where you simply don't respond to it because you don't believe they have the right to be suing you there. And then and then they'll get a default judgment, and then when they try to enforce their California judgment against you in New York, you then fight them at that time and you say that you never had an opportunity to defend yourself and you want to be sued properly in New York if that's what they want to do. And a lot of times the New York courts are very open to disregarding a default judgment from another state and giving you the right to defend yourself in your home state. Whether that's going to happen is a factual question, and that's if you're thinking about defaulting, that's definitely something that needs to be talked about with the lawyer before you just go ahead and default. But it is something that people do. Okay, and so this is just a little joke we have here. Hello, my name is Jerome, and I will be your summons server this evening, right? And that's how it is. Someone shows up that doesn't look like they're about to sue you, and then you open the door, and they just hand you the good news. So, very, very exciting. All right. So now, one of the first questions is with people like, am I going to lose my house? Am I going to lose everything? What's going on? What do I need to do to protect myself? And just say, all right, this is what happens when people call me. And I say, all right, let's start at the beginning here. Who was sued? and we're going to talk a minute about how to read the caption and see who was sued. But these are the different, this is who could be sued: an individual, meaning yourself or someone else; a company, meaning your company or someone else's company; an association, an organization, or an alias. Sometimes they don't even know who they're suing. They just sue John Doe. So you got to take a look, and you have to see who is suing and who is being sued. And once you see that, you're going to have a lot more information about what's actually going on here. So, all right, let's talk about deciphering the case caption. So this is a case that I filed yesterday. It's like $15 million case that I just filed yesterday. Very exciting after months of work to finally have this thing sitting in the federal court system. At any rate, so this is what you're looking at here. This is what a lawsuit looks like. The very top of it in blue, this gives you the case number, and the document number and the date that it was filed and how many pages it is. Depending on what court issued it, it may look a little different, but sometimes people just send you lawsuits that they never even filed. It's just some crap that they just typed up, and they have no intention to ever file it. And so that becomes a question: is there a docket number? Was the case actually filed? So, in this case, the civil action number is not typed in here, right? You can see on the right, it says civil action number. I didn't type in the civil action number, but the stamp is on. This was electronically filed. The stamp is on it, so you can see that it's case number 05482. So this is legitimately a federal case. This was in fact filed. So what else are we looking at here? What court was this filed in? This was filed in the United States District Court. So this was not filed in state court. This was filed in federal court. What does that mean? Well, first of all, it means that there's going to be less opportunity to delay the case, and it's going to be stricter and more serious because the state courts are backed up from here to Kalamazoo. It's very difficult to get the state courts to even hear the most basic motion at this point. They're so delayed. The federal courts are still moving right along. They were moving straight through COVID. And since this is a federal case, this is a serious higher level case, which is going to be moving faster. Plus, in most situations, there has to be at least $75,000 at issue, not including interest and penalties. So that means this is going to be a relatively large case. The fact that you even see this sitting in federal court. It also means we're going to need to check whether they have the right to be in federal court, or whether we can force them back out of federal court and back into state court. So under it, it says Southern District of New York. There are different districts of federal court. The Southern District is in Manhattan, so that means they sued us in Manhattan, New York. Or in my particular case, we're suing them in Manhattan. What else do we have here? Okay, so you're going to have at least two groups of people here. You're going to have the plaintiff or plaintiffs, and you're going to have the defendant or defendants. The plaintiff is the person or entity who is doing the suing. There can be more than one plaintiff, just like there can be more than one defendant. In this case, my client is Converged Compliance Solutions, Inc., who's the plaintiff. And we are suing a whole bunch of companies and individuals, some of which are in the United States and some of which are outside of the United States. So you can see we're suing XOP Networks, Inc., which is a corporation in the United States. We're suing XOP Networks in Latvia, which is a Latvian company. We are suing XOP Networks India, which is an Indian company, all affiliates of the foregoing. And then we're suing two individuals, Sudhir Gupta and David Harding. So this gives you some sense of how these things work. Now, here's an example of a longer, more complicated caption, which you certainly could see in construction cases and larger, more complicated cases. So in this case, there are two plaintiffs, right? National Fire Insurance Company of Hartford and Continental Casualty Company. They're grouped together because they're two sister companies that were both providing insurance. They're both owned by CNA, but regardless, they're two separate companies that are suing. And then you've got a V here, right? So the V tells you who's on the other side. So on the other side, you've got Lafayette City Parish Consolidated Government of Lafayette doing business as the Lafayette Utility System. DBA is interesting because a lot of times you've never even heard the main name of the person with the DBA. You only hear what they're doing business as. So you might be like, oh, the Lafayette Utility System. Yeah, I'm familiar with that. Now I know who that is. So the DBA is important. And the other defendant is National Cable Television Cooperative, right? So you see that you've got the plaintiff, then you've got a V, and then you've got a defendant, and then it says and then another defendant. So really you want to look for those Vs. Those Vs are indicative of what's actually happening in this case and who is suing who. So you see then there's another V between National Cable Television Cooperative and Travelers Casualty and Surety Company of America. So what does that tell you? That tells you that in this same lawsuit, National Cable Television is suing Travelers, right? And they give them fancy names: defendant, counterclaimant, counterclaim defendant, and there's a caption at the bottom saying why they're called what they're called. That's not that important. What's important really is the V's. The V's that you see on the left just tell you who's suing who. And that's really the important thing here. And this one has the case number entered directly on the right. And again, you can see the blue letters at the top telling you when the case was filed, what page you're on, what document you're on, the case number. And in this particular case, we're in federal court, but this time we're in federal court in the District of Kansas rather than the Southern District of New York. All right, so what have we got next here? What to do after you've been sued. Don't panic. That is the most important part. Many times people panic and do really stupid things that cost them their insurance coverage and ruin their relationships with with subcontractors and employees and suppliers and a lot of other people, and make them look guilty and potentially ruin their case as well. So that's the first rule of getting sued, is not to panic. Second rule, read the court documents. Once you understand what's going on, you're going to be in a much better position to defend yourself. So you don't panic, you just stop, you read the court documents, and then you decide how you're going to move forward once you have done those other things. So, okay. So what are some of the claims that you might encounter? Usually, most civil cases fall into two categories. They fall under breach of contract and personal injury / property loss. So breach of contract means there was a duty, meaning that there was a contract, right? Someone has a duty to do something for someone else. There was a breach of that duty. The person did not do what they were supposed to do. And there were financial damages that resulted from someone not doing what they were supposed to do. So that's one of the two things that people frequently get sued for, is breach of contract. The other thing is personal injury and property loss, meaning that someone damaged someone else's property. So in a case like that, you have duty. Again, you're going to have a duty to be careful, right? A breach of that duty. You were not careful, and as a result, there was property damage. So so you may see both of those, one or both of those two things. And again, that doesn't mean that you did it. It just means that that's what you're being accused of, and that's where your defense is going to lie. You're going to come up with something. And well, I shouldn't say you and your lawyer will come up with something, probably many somethings, that are going to argue that you are not responsible on those grounds. Maybe you did not have a duty. Maybe you did have a duty, but the other side breached some duty that they had, which made it impossible for you to fulfill your duty. or maybe you did not breach, or maybe you breached, but they forced you to breach because they breached first in some other way, or they didn't do something that they really needed to do. Um, and and things like this. This is very realistic. All the time, people they'll be like, you didn't do the following job, right? They'll be like, you didn't not remove the asbestos in building C like you were supposed to do. And then my client is going to say, the super didn't open the door. He kept we had all the guys sitting there with all the tools, the trucks were there, we were waiting. We kept calling and calling and calling. The super kept saying, I'll be right there, I'll be right there, I'll be right there. The super showed up at 2 o'clock. At that time, we had left already. We're paying people sometimes per hour, sometimes for the day. They cannot first get there at 2 o'clock. So don't tell me that I didn't do the job because you didn't open the door. Opening the door was your part. And a lot of times when I negotiate construction contracts, this is just the kind of thing that comes up, is when I'm representing the GC, the subs are going to be like, well, wait a second here. You're asking me to agree to all of these things, but that means your guys have to actually do their job. You have to open the door. You have to give us site access. You have to give us the drawings that we're going to need. You have to make sure that we have a place to store our tools. You have to make sure that we have the supplies that you're supposed to be supplying. You have to make sure that there aren't other guys working in the area we need to be working in and messing up our work. There's a lot of things that you need to do as well, GC, if this contract is going to work for us, right? And this is usually what happens: is someone files a lawsuit and they're seeming so righteous, and their lawsuit makes them seem so righteous. But then once you start getting into the facts of what actually happened, then you realize that it's nothing but a big mess of everybody messing up and so many people not doing their job and not reacting properly or intelligently like they should have. And you've got 100 people who are, or I should say, you got 20 people who are 5% at fault, and nobody who's 100% at fault, and it's a big mess. And that's the reason that almost every case gets settled, because at the end of the day, everybody realizes that they're not as righteous as they thought they would be, or they may have thought that they were. And that's partially the purpose of court, is to help people realize that. Okay, and so now in the cartoon, he's saying, and just how far in front of you was your employer dangling this carrot when it poked you in the eye? Funny, right? Injecting some humor. Is there any questions at this point? No? Okay. All right, so I'll go on here. So here's some of the things you need to do. Determine how long you have to respond to the lawsuit. Sometimes this info will be in the court papers, or you can always ask. All right, so the court papers is going to have two things. They're going to have the summons and complaint, or the summons and notice. Regardless, the part that you receive is intended to give you notice of the lawsuit. And either it's going to tell you you have 20 days or 30 days to respond to this lawsuit, or you just need to know how many days you have by checking the law and seeing how you were served, and based on that, calculating how many days you have to respond to the papers. This is certainly around the time you want to be getting a lawyer, because this gets complicated figuring out if service properly occurred, and if so, when it was, and how to calculate the number of days that you have to respond to it. But that is the first thing. And when someone contacts me about representing them in a lawsuit, the first question that I have is, when were you served? So I know when it is that we need to get a reply in by. So the next thing that you're going to want to do is notify your insurance carrier. Basically, if you expect somebody to potentially pay for your litigation and pay for the damages that you may have caused, if they've agreed to do that as your insurer, then you are going to have the obligation to notify them as soon as possible that something happened, so that they can begin defending you. And if you don't notify the insurance company because you think you're going to settle it privately, or you don't want your rates to go up, or whatever your reasoning is, you may end up having no insurance coverage. You may void your insurance coverage by taking away from the insurance company the opportunity to start taking actions to lower their risks and their costs in the case, and potentially protect you better as well as themselves. They may want to get people down to inspect the scene and take pictures, and it's just basically start preparing some kind of a defense. And so you need to let them know. Okay, all right. That's a good question. Yeah. That is something that happens all the time. So someone's asking, well, what if you get a letter saying that you're going to get sued, but they haven't actually sued you yet? Do you still notify the insurance company? Generally, what I tell people is, if it's a letter from a lawyer threatening to sue you, then you should put the insurance company on notice, because there's a relatively high chance that there's going to be litigation. If the letter is not from a lawyer, if it's just from a regular mere mortal, then you may not notify the insurance company. Again, you've got to use your judgment as well here, right? Like, sometimes someone will send a very detailed letter, and they'll make it, and it just feels very clear that they are in fact about to file a lawsuit. And in a case like that, again, you want to put the insurance company on notice. But more often than not, we wait for an actual lawsuit to come, or a letter from a lawyer saying that it's going to happen. So next, you need to safeguard evidence and preserve memories. This is really important, because a lot of times when people sue you, they have false self-serving information that they're relying on. You need, first of all, setting anything else aside, you have a legal duty not to destroy evidence that could be relevant in the case. It's not up to you to decide what's relevant and what's not relevant. You are obligated to put a litigation hold on, meaning that you don't go erasing emails, you don't go throwing away papers or destroying papers, that you don't destroy any media or any source of information which could contain information which could lead to evidence in the case. And notice, I'm not just saying you can't throw away evidence in the case, you can't throw away information that could lead to evidence in the case, which pretty much means you can't destroy anything that that could be a source of information interpreted as broadly as possible. So that's the law. But setting aside the law, you actually want to go documenting your entire case before it's heard years later and no one even remembers anymore what's going on. This is extremely important, because most cases settle after discovery. Discovery is when each side gets an opportunity to discover all of the evidence that the other side has. They see all the evidence that is for and against them in their case. And usually it's at that point that people see the strengths and weaknesses of their case, and they become more open to settling the case. And that's why most cases settle after discovery. So what are you going to want to do? Say if this is a matter of physical construction, you're going to want to go around and take as many pictures as you can of the work that you completed. Ideally, you have some pictures from before you did the work to show that what you did was in fact quality work. Keep all invoices that have been sent to you, invoices that you've been sent. You want to preserve all emails that may discuss this, any papers that have been signed, any notes that you may have written to yourself, even on the back of a napkin, to memorialize discussions that have been had, or remind yourself of things that you need to do because of discussions that have been had. Drawings, if they've been provided, you want to keep it. Also, you are welcome to reach out to, to speak with your employees, and reach out to subcontractors, suppliers, vendors, anyone who may have witnessed it. You're welcome to just find out what their point of view is on what happened. And you can also keep in mind, you can call them and you can record it. So if they change their story later, you can use that against them. The fact that, they said one thing when they were talking to you, then they said something else when they were talking to the adversary. Were you telling the truth then, or are you telling the truth now? Also, you can ask them for a written statement of what happened just to preserve their testimony. And and then they can sign off on that, and so you can get written statements. So there's nothing stopping you from reaching out to anyone who could potentially be a witness in the case, and and finding out what it is that they're going to say, and that helps you to get an idea of the strength of your case. And finally, you're going to want to find an attorney. Now, the insurance company may offer to give you an attorney, but the insurance company has an inherent conflict of interest in that their job is to protect themselves from having to pay the most money possible. So they may take actions that are not in your own best interest. And so you're better off getting your own attorney. And a lot of times the insurance company can be required to pay, if you have valid insurance coverage for what happens, the insurance company can be required to pay out your company, I'm sorry, your counsel, based on conflict of interest. So you really want to look around and try to get your own lawyer to protect you, even if there is an insurance company. All right, so another important question that comes up is, how do I talk to my employees? Now, this is an important question. We'll go back to this for a minute. This is an important question of how do you talk to your employees, because you can destroy the culture of the business. You can make them think that you're a bad person. You can alienate them. And also, they are free to talk to the adversary. They may have a very good relationship with the adversary. The adversary may be another company that's offering to hire them, that is paying them to give them information about the case. The adversary can do very, very dirty things. In one of the cases that I was in, the adversary, um, she was just a professional liar. There's just not another way that I can say it, is what she is. And she called up one of my employees, and she was telling the employee that she has cancer and that she was dying, and that the lawsuit was causing her to get much sicker much faster, and that by the employee testifying, she would be murdering the adversary, and that the case has to end, and that the employee has to take an important stance in making the case come to a conclusion in order to save the life of a cancer victim. And this employee, I think like her mom or someone in her family, had cancer. So she felt extremely bad about it. And when we found out about it, we were just like, she does not have cancer. She is a liar. She was just trying to get you as a key witness not to testify in this case. But, my point is that employees become pawns in litigation. And so you need to make sure that when you talk to the employees, first of all, that you make it clear that you're the good person. Even if you're the good person, if you act crazy, if you're rightfully enraged, then they may get the feeling that you're the wrong one, that you are actually crazy, and that the adversary is nice and friendly and is better than you are. So, you want to be careful of what it is you say to them, and say it as if you're talking to the adversary or talking to the media. And then calmly, just, maybe you want to call the employees in, and this applies to contractors, subs, whoever it is you need to talk to, and just say, listen, we've been sued. Something happened and we've been sued. And they may have questions like, am I going to get sued? If I'm going to get sued, are you going to pay for my lawyer? Who's going to pay for my lawyer? What can happen to me? And you may want the employer to talk to your lawyer. I'm sorry, the employee to talk to your lawyer as well. So, and sometimes we do that. So you may want to, or you should, speak with your lawyer before you go speaking with employees and other people. But these are all things you're going to need to deal with, and you're going to need to deal with it correctly. And PR is going to play a very important role here, particularly if the press calls you and you have to start making press statements and all that other good jazz. So, okay. So you have a lawyer. Now what? So here are some of the things that come after you get the lawyer. You're going to need to answer the lawsuits. You're going to need to attempt settlement, or you don't need to, but usually you're going to attempt settlement negotiations as early as possible because litigation is expensive and cases almost always settle. So the sooner it can be done, the better. You're going to want to figure out, are you going to sue the other side for something? Usually when someone sues you, you can sue them back because however they feel about your guilt for what happened, you feel just as strongly about their guilt for what happened. So usually, right, you say, you punch me, I punch you. And so you end up suing them, sometimes suing them for a lot more money than what they're suing you for. You can do nothing and a default judgment will ensue. Sometimes people do that, because they've been sued in another state and they don't want to deal with it, or because their company is already broke, they have no money, and like, I'm not going to pay for a lawyer. They want to sue me, let them sue me. There's no money here for them to get, right? And then you can just move to dismiss the lawsuit. Sometimes the lawsuit just has no validity, and you will just move to dismiss it outright. So, what are the stages of a lawsuit? So first, you're going to get served with a complaint, right? You're going to get a summons that gives you notice, and you're going to notice of the date and time that there's going to be a hearing, sometimes how many days you have to answer. And then there's going to be the complaint, which is a list of what it is that they feel that you've done wrong. You are then going to respond with an answer, basically denying what it is they said in the complaint, and then stating what it is that you're suing them for, if you're suing them, as well as putting in some defenses for yourself. And then you can also we can make a motion to dismiss or a motion for summary judgment, meaning we say this lawsuit is just BS, like just throw the lawsuit out. This lawsuit does not need to go any further. And sometimes we win on that. Or we can make a motion for summary judgment, which is saying, don't just throw it out because it's BS, actually rule that they have no rights and take away their ability to ever file this lawsuit again based on these facts. So those are things we can file. Assuming the case goes forward, there's going to be discovery, which is the exchanging of evidence in the case, which usually serves to help people understand their case is not as strong as they think that it is. Discovery includes things you may have heard of, such as requests for admission, interrogatories, requests for production, and depositions. Then there's going to be other motions that we're going to make throughout the course of the case based on, witnesses, availability, and, whatever it is that we need. There'll be a bunch of other motions. And then eventually there'll be a trial if we don't settle at some point ahead of the trial. So, Matt, you're going to want to manage the costs of the litigation. Litigation can be very expensive, and there are many decisions that you're going to need to make in the litigation, which carry a trade-off between higher costs and greater benefits. For example, are you going to conduct depositions via Zoom, or are you going to make everybody fly in and get deposed in person? It's scarier to get deposed in person, but it's also more expensive to drag people in person. Are you going to do video depositions, or simply just make an audio recording and a transcript? How many witnesses are actually going to be deposed? Are you going to have 5 witnesses, 10 witnesses, 20 witnesses? This gets very expensive very quickly, but the witnesses do help. Now, interestingly, a lot of times I get called in on large cases as attorneys, simply to help manage the cost of litigation, because my client will say to me, listen, I'm in a major case here, and I like my current counsel, but they're representing their own interests. And so I want you to serve almost as my lawyer, as in-house counsel, overseeing my lawyer and making sure that they thought of everything that they should have thought of, and make sure that they're doing strategies that make sense for me, that don't just make them the most money, but make but that work out for me in my best interests. And a lot of times I save people a lot of money because I'll just say, why are we doing this? Why are we doing that? What if we did it this way? What if we did it that way? And they'd be like, well, that would be $50,000 less. I'd be like, yes, that would be $50,000 less. They're like, but the trade-off would be A, B, and C. And usually my client is like, well, I'm fine with that trade-off. That's just, of course, I want to save that $50,000. That's a tiny trade-off. And so, a lot of times it if it's a major case, having an attorney like myself, whose job is just to serve as a second set of eyes, just to be your attorney standing between you and your law firm, particularly if it's a big law firm, can make an extraordinary difference. If it's a one-person law firm or a two-person law firm, it's just silly, right? Like me sitting there fighting with someone else. If we're on the same team because we specialize in different things, great. Or we can't say specialize because our practices focus on different things, then great. But but usually it's a bigger law firm, which is much more expensive and much more inefficient. And I've been asked to manage the costs of that. And also, when we talk about the cost of litigation, you're much better off with a small law firm. Large law firms are extremely siloed, meaning that they see the most narrow picture possible. They will have one particular legal issue only, and they will look only at that legal issue and try to figure out what to do about that. But they don't see the big picture of everything going on around and how you want to spend your money and what's ultimately going to be the most beneficial for you and what are all the facts of your case and what's your strategy. And, that's something that a much smaller law firm like mine is much better at, because we know what it is you're trying to protect, how much money you're willing to spend, what the insurance company is willing to pay for, what the insurance company is not willing to pay for, what is the personality of the other side, what are the witnesses going to do. I'm sitting here thinking about all of these things and talking to you, and we're saying what's going to make the most sense here. We're playing chess. We're not just going in a straight line. We're thinking carefully and trying to put our pieces all over the board to get the maximum possible benefit per hour worked at every possible opportunity. So, cost containment is something that I'm happy to talk about with you, and I do talk about with my clients on a regular basis. So, what are the ramifications of the litigation? Litigation has a lot of ramifications, including bad PR. A lot of newspapers scan the docket and they look for interesting, juicy gossip to talk about. And so you should expect that if there's litigation, there's going to be calls from the press, and you should be prepared to answer that. Also, this stuff goes online. Like, they write articles about it and it goes online. And then when someone Googles you or your company, the stuff shows up online, and a lot of people get very upset about that. But that's a ramification. Another ramification is raised insurance rates, right? You get sued, your insurance goes up, or your insurance company just drops you. Next is lost customers. If customers get dragged into the litigation, or if they're the ones who sue you, or they get the idea you did something wrong, you could lose the customer, and you can alienate a lot of people, employees, suppliers, subcontractors, family members. Whoever it is that gets dragged into the litigation is not going to be happy. So when we figure out how we're going to deal with the litigation, a lot of times a risk, there's the cost analysis, but there's also the risk analysis. What could happen, and can we live with it? And how are we going to deal with it? I've had some clients who, excuse me, I've had some clients who have said, you know what, let's just settle the lawsuit for 50 cents on the dollar. for 30 cents on the dollar, I'm making too much money. This is just going to hurt me. It's not worth it. Let's just pay them off at the smallest amount that we can and have them sign a non-disclosure agreement that they're not going to go posting about this or telling people about it or trying to steal my employees or doing like they're more concerned about other things besides the money. And so that's what we do in that case. So I want to end off here on asset protection because people's primary concern a lot of times in a litigation is what's going to happen to me. Are they going to get our family home? Are they going to destroy my business? Are they going to get access to my bank account? What about my investment properties that I own? What about property that belongs to my wife that's just got my name on it for convenience, or that belongs to my parents because I pay their bills? What about my retirement funds? All of this becomes an issue. And asset protection is another discussion that we might have as well at the beginning of a case is, okay, what can they take and what has to happen in order for them to be able to take it? And what are you legally allowed to do during the pendency of the case? So, all right, so some of the questions I have is what's at risk in the litigation and after it? Should I start a new company? Am I going to get sued personally? How do I protect my family assets? And sometimes people do that. Sometimes people go and they start another company to get out of a non-compete agreement or something like that. And that could be a completely valid strategy, by the way. It's not illegal to do it. It's just that we need to do it properly. There are proper and improper ways to do things. There are legal and illegal ways to do things. And much of the time, people do things that are illegal when they could have done the same thing legally if they had just spoken with a good attorney about what they want to do and how to accomplish that kind of thing legally. So, there are a lot of things that we can do to protect you in the event of an adverse judgment, and also to make an adverse judgment difficult or impossible to ever happen to begin with. So a lot of times after speaking with me, people feel a lot better than they did beforehand because they understand that we're going to be able to fight this for years on end if that's what we need to do. We're probably going to get it to the point of a settlement, and many of your assets may not necessarily be at risk because of things that we'll be able to do in the event of an adverse judgment, or other potential, or there may be other potential facts that work in your favor that will make it much more difficult for them to take anything from you. And so even if they get a judgment, it may end up having to be settled for pennies on the dollar because there's no good way to get at you. So that's a consideration. And then don't forget about alternative dispute resolution. Sometimes the contract calls for arbitration, mediation, or negotiation. And if you can get this, it's really, really valuable because you oftentimes get an experienced judge as the arbitrator or the mediator who will look at the facts from both sides and hammer home to people the weakness of their case. And then you may be, if they're good at what they do, which they try to be, so that lawyers pick them on a more regular basis, then you may manage to get the entire case settled. So sometimes the court will force mandatory mediation before allowing you to go to trial. Sometimes you can both just agree to go to arbitration or mediation, and it's well worth it. Sometimes when the court forces you to do it, the court really just gives you like crap people that are associated with the court. But if you're going on your own, or you're able to go through the American Arbitration Association, stuff like that, you can get excellent, excellent people who can get the whole case taken care of. So if the other side is rational, then a lot of times they'll agree to go into voluntary mediation and see if things can be figured out. So now the question becomes, what if I'm 100% guilty? You may be 100% guilty, but they have to prove their case, and then they have to be able to get at your money. Those two things have to happen, and those are very, very difficult things to happen. Like, we can make them have to prove every element of every fact, and it goes on and on and on, and then everything is questionable, or so many things are questionable that most of the time, even if someone is completely guilty, the case ends up settling maybe for a little more if you're guilty rather than not guilty. And then sometimes there's a judgment, but because there's so few assets available, the judgment gets settled for pennies on the dollar. So it's not the end of the world. You don't need to panic about it. You just need to calm down and be realistic. And the quicker that you just sit down, make a plan with your attorney, and start pursuing the plan, the quicker and easier and cheaper it's going to be to knock this whole thing out and get on with your life. So that's all I'm saying is you do have options, so don't freak out. Again, this presentation is for instruction purposes only. It does not create an attorney-client relationship. It does not constitute legal advice, and there are many other facts which could affect the outcome of any of the hypothetical fact scenarios presented here. So if you want to plan to update your contracts to help and avoid your liability for potential litigation, or if you have a litigation, or if you want to sue someone, please feel free to reach out to me. My contact information again is right here, and we can make things better than they are now. All right. I'll be staying around for questions if anyone has questions, but I'm going to end the recording at this point. And I thank everybody very much who took the time to bear with me through this.